wonderful.
I'm a little shocked that you were permitted to do this.
Jeff just told me, oh, we let people in all the time, and this is standard, and
I think they changed their policy over the years.
Uh-huh.
In '98, Fox News was trying to come in and interview me.
Yeah.
They had heard that I had
Uh-huh.
taken pretrial polygraphs
Yeah.
and passed them,
Yeah.
but then the accusers refused polygraphs, of course, on the advice of their lawyers. And so Fox had this scheme. They wanted me to take a live polygraph with their FBI expert, and I agreed to it.
Uh-huh.
But the prison wouldn't permit it. But that was '98, and
Right.
I think since then there's been a little pressure to change some of those policies.
Because I visit Shanley in prison.
You do?
Yeah, and they will not, and I've written them twice.
Really?
They will
won't
not
permit
let
it?
me in with the camera, there's no way.
It's interesting because down there in Mass,
How's our sound going? How's everything going? It's good. Good.
in Mass, all their other visiting rules are far relaxed next to here.
Well, he told me that other people can have been on camera for stories.
Oh, really?
But they won't let
But
him,
not him, yeah.
because he's too infamous, his case is too shaky
Yeah.
and weird. I've spoken to everybody, I've read everything. He didn't do what he's
I agree.
accused of. He
I
did
agree
not
with
do
that.
He told me that.
Yeah.
And,
I agree with
and
that.
And I believe him, and I believe other people that he didn't do that.
The repressed memory theory behind his case is simply not.
Right. Last week I was at Harvard with Richard McNally.
Oh,
He's one of
yes,
their leading
yeah.
experts.
Yeah.
And he said he'll give me an on-camera interview. So what I'm doing is I'm lining up legal experts, psychology experts, along with your priests
Terrific.
who have been accused. And so far I have one priest. His name is Roger Jakes from the Archdiocese of Boston, who was accused, cleared, but it took him 14 years,
Right.
and his life is ruined. And so what I want to do with this film at present is to weave in all your stories.
Sure.
And to come to a conclusion that there's a great injustice here and something needs to be done. So I really want to appeal to a public audience. I hope to get this on television.
Sure.
So could you say that you give me, because I don't have any really...
Oh, sure, yes. I do give you permission to use whatever I say in a public forum and edit it as you wish.
Okay, great,
Okay.
thanks. And I will be very sensitive, as I mentioned
Sure.
to Charlene. I know you have a case coming up, and what I'll do is, what I did with Raj is, John, he and I, we rough edited what he said.
Yeah.
And then I, mailed him a DVD, he got a chance to see it,
Okay.
and he loved it.
All right.
So I'll do the same thing with you. We'll rough edit it, do you know what I mean? And
I would not be able to
I'll
see
send
the
it to
DVD,
Charlene.
but yes.
And
But
so- right.
you don't have to worry about that. I've
Okay.
talked with the attorneys involved, and we have the parameters down in
Okay,
terms of, there's so much that's already public.
right.
I mean, the legal case only came about as a result of Dorothy Rabinowitz's articles, so all of that was already public, and that kind of opened the door to looking at another side of this whole
Right, I've read her
situation.
articles. She was right spot on.
Yeah, she's very good.
Yeah, I hope to contact her. I heard she's a very difficult personality, but I'm going to try to contact her to see if she'll speak to me, given that we've had this interview. So,
She may. I haven't heard from her in a long time. Occasionally, if I come across something interesting, I send it to her. But I see her periodically on the Journal editorial report, and she's a really feisty.
yeah, a New Yorker.
Very much a New
Yorker.
Yorker, yes, she is. She is. So,
Well,
where would you like me to begin?
Okay, so let's start with what I want to do with the film, with you and the film, is for the arc of your story to unfold.
Okay.
What happened, and then how you felt. I want to appeal to your feelings and your family and how it affected. But let's start with what happened to you. And we have as much tape and as much time as you want. But what we'll do is I'm going to edit it down, of course.
Of course.
So that you'll only, in the course of this film, probably only get 12 minutes max for this film. There's a possibility where I could do another follow-up film, regarding your specific case. So, so there's different purposes. But for now, I'd like to get the arc of the real salient points of your story.
Okay. Certainly. It's bizarre, of course, but at the time I was accused, I was admissions director for the Servants of the Paraclete Center in Hampshire Springs, New Mexico, and we were neck deep in a controversy about 25 years earlier, in the late 60s. The center had treated Father James Porter, and at the time Father Porter was there was actually no treatment. It was simply a place he was sent more or less as a punishment by Fall River.
Turn this
Sure.
so more to the camera. Yeah,
Sure.
yeah, that's great.
By the Fall River Diocese. And as the Porter case unfolded, I'm sure you remember it.
I live in Fall River Diocese. I live in Fall River. I live in a rectory. Yes.
It was 92, 93 that it really became nightmarish for the servants of the Paraclete, because they had a completely revamped and very successful treatment program for priests. Some accused and some not. Some treated for depression and other issues, alcoholism. They had a very supportive and successful program. But they were being held civilly liable for not acting in 1968 as they would in 1992. So there's this retroactive sense to this whole picture that has really been disturbing, because they didn't have the level of treatment in 68 that they had in 92. They were declared negligent. And Porter was sent there really as for a kind of spiritual renewal. In the 60s, at least from my reading of this, the issues for which he was accused were seen primarily as a spiritual problem, as a sort of an addiction problem. And so he was sent there, and he spent about 60 or 90 days in New Mexico with the servants, and they released him. His diocese reassigned him, and then in the 90s, the Paraclete Order was sued, I think 80 individual lawsuits over the course of 1992 by Father Porter's accusers and victims. I can't imagine that they were all victims, but I have no doubt that many were. And it was at the height of that whole story that I was accused. And I'll never forget the day. It was May 3rd, 1993. And I had been at a meeting with some of our staff, and we got into a big argument because we had an increasing number of priests coming to the Paraclete Center accused of sexual misconduct. More often than not, the accusations were 20 or 30 years old at the time they were brought, but some were current. And as the admissions director, I took a position that we must not simply preclude the guilt of each one of these men simply because they were accused. And what brought it to a point of contention, I think, with that staff was that one particular bishop had a man who was accused of what would be generally called boundary violations. And the bishop wanted a diagnosis of pedophilia so he could dismiss the man from priesthood. The diagnosis simply wasn't realistic, it wasn't accurate. And so to its credit, the center refused to let the bishop dictate the diagnosis. And he was furious with them. And so we got into this discussion about whether or not we should be precluding the guilt of these men. And on that same day I left that meeting, I drove home. I shared an apartment with another priest who was on our faculty, on our staff, as the aftercare director. And there was a knock on the door about 6 that evening. It was 2 police officers from Rio Rancho, New Mexico. And about a week earlier, there was a skirmish of some sort. A man was arrested for DUI right outside the apartment, so I presumed that this was in reference to that. I opened the door and they asked if my name was Gordon MacRae, and I said yes. They asked if I had a driver's license. I gave it to them, and they said, "You're under arrest for charged with 2 indictments from the state of New Hampshire, alleged to have occurred," this was 1993, alleged to have occurred between 1979 and 1983. And the 2 indictments, which they showed me, contained only initials. So I had no idea who was accusing me. There were no details. The indictment simply listed felonious sexual assault. And the initials on the indictments were JG and TG. I had no clue who this was. I was taken immediately to a county jail, and I had no idea. This was my first experience with the criminal justice system, in the sense that I was really naive in terms of how this worked. At the county jail, I was immediately presented by a local detective with papers to sign, waiving extradition to New Hampshire. And something told me not to sign them without consulting counsel. The pressure to sign them was enormous. But I found out later that if I had signed that paper, I would have sat in a county jail in New Mexico for up to a year, waiting for New Hampshire to come and get me. Whereas if I refused to sign, then I was entitled to a bond hearing within 24 hours. And so by refusing to sign, I was released on personal recognizance bail the next day in New Mexico. New Hampshire officials, I understood, were furious because they were told that we'll get him to sign these papers. And so there's a game here that's played that's very manipulative from day one to pressure defendants into signing papers, into admissions of guilt, that makes the whole system easier, but not for the defendant. So once I was released, there was really no notice at all in New Mexico. The local papers that had daily headlines about the Porter case and the lawsuits against the servants of the Paraclete took no notice of the fact that I had been arrested and released. And but then I learned that the detective in New Hampshire who choreographed this case, as opposed to investigating it, personally faxed 40 pages of his police reports to a New Mexico newspaper. And the headline that night, around May 17th or so, was "Paraclete Official Indicted for Rape." And that was the end of my employment. It was the end of my ministry. It was the end of my career with them. The order, the servants of the Paraclete, was very supportive of me, and they believed in my innocence, and I believe they still do. And they permitted me to remain there with them, but I had to take a leave from my job, from my ministry, which I did. And so from my office there, which I was able to retain, I started to fight the case. It was months before I even knew who was accusing me. And that's the most Kafkaesque part of this tale. I since read Franz Kafka's The Trial. And that was the story of my life, because every step of the way, his protagonist is trying to determine what exactly am I on trial for, and he could just, at every corner, could not find out anything. And it was a nightmare to read. And but I became really engrossed in the trial. I had a New Mexico attorney who came out of the blue actually, and offered to take the case after reading the newspaper and work with me on it. And we started to obtain discovery, and then learned who the accusers were. And there was something from day one that was very disturbing about the discovery. All defendants and their counsel are entitled to see everything that the state uses against them. But the discovery in this case consisted of no investigation whatsoever, simply the police reports of this one detective's interviews with each of these brothers. They turned out to be 3 adult brothers. In the end, there were 4 from the same family who accused me. In other cases that I had become aware of, only later, only through other discovery, this detective, James McLaughlin is his name. In fact, he's from your hometown, Fitchburg, Massachusetts. He is the sole sex crimes detective on the Keene Police Department. At that time, Keene, New Hampshire Police Department. At that time, in '93, Keene was a town of about 28 or 29,000 people, with a police force of 30 and a full-time sex crimes detective who did nothing but investigate sex crimes. It's bewildering. It always has been bewildering. But he choreographed this case, and in all other cases up to that point, he meticulously audio and video recorded every interview with complainants. We were able to obtain his reports in another case involving another priest that preceded the claims against me by about a year. This case came up in 1990 and 91. And the accuser in that case has even come forward and has given us evidence that he said that he was not only audio and video recorded, but he was given a polygraph by the detective. And he was told that these recordings are absolutely necessary, that he can't proceed in the case without recording every interview and preserving the recordings for evidence. A year later, he interviewed these three brothers, 2, 3, 4 interviews each. These are not children, these were men in their late 20s. And he recorded absolutely none of his interviews with them. So we had nothing to go on but these police reports. And they came forward separately over the course of several weeks. The first one had we never knew even how they came to be in Detective McLaughlin's office. It was never clear to us whether they had gone to him with a complaint, whether he had gone to them. There was some evidence from others that that was the case. We knew that they went to personal injury lawyers, but there was a conflict throughout all of the investigation and even the trial. We never got an answer on who they went to first. At trial, the accuser said that he went to Detective McLaughlin, who referred him to a contingency lawyer. Detective McLaughlin testified that the accuser went to a contingency lawyer who referred him to McLaughlin. We never got to the bottom of this. In the reports, however, the first of the three brothers to come forward, Jonathan Grover, accused me and another priest of both simultaneous and separate abuses of him. He claimed that these abuses occurred when he was 10 years old. I wasn't ordained a priest until he was 14. And the other priest he was accusing of acting simultaneous with me was not present in that community until he was 16. As time went on, we were able to determine that. But throughout this investigation, no one had obtained my personnel file. No one had sought to corroborate these dates. No one had done anything. Simply, we have an interview, now we have an indictment. And so my attorney from 2,000 miles away was saddled with having to investigate and ran up against roadblocks every step of the way. My diocese would not cooperate with the investigation. Priests of the diocese who were with me in those places at those times would not answer requests for information, even the most simple things. One priest we wrote to replaced me in a parish, and our only question of him was, can you corroborate that these 3 offices in this rectory are where this diagram says they are? And he wrote back and said, I will not help you and do not see the need for any communication with you. It was mind-boggling. So we were on our own, and that was made very clear. But investigate we did, and we were able to show that the other priest accused was not present in this community until Jonathan Grover was 16, and here he is accusing us of raping him at the age of 10, and that I was not there until 14. At about the same time we were able to demonstrate that, Jonathan Grover disappears into the background and another brother comes forward with a whole new set of claims and a whole new set of dates and times and places. The other priest, Father Stephen Scruton, who had been accused over and over and over again by others, was just omitted from the picture as if his name never came up. The second brother said, was David Grover, was then about 28, said that he was driving his car, and again he appears in Detective McLaughlin's office. No idea how, no knowledge of how he got there or why. He claimed that he was driving his car and heard a radio announcement about the Diocese of Fall River agreeing to a mediated settlement in 80 lawsuits against Father Porter and the diocese. And he said that he pulled over and began to weep because this flood of memories of his own abuse came into play. He claimed that at the age of 12, I raped him in St. Bernard's Rectory in Keene, New Hampshire. And again, this was thrown out there in a police report with no attempt to corroborate anything. I arrived at St. Bernard's Rectory in Keene, New Hampshire, and it was demonstrable on June 15th, 1983, 2 weeks before David Grover's 18th birthday. So I could not have been there when he was 12 years old. He told this whole story of being repeatedly raped between the ages of 12 and 14 in the St. Bernard Rectory while visiting me, overnight stays, all of this. And then 2 months went by, and he appeared in the detective's office again, this time with a whole different story. His new story was that in 1982, I had brought him to another parish where he was raped by 2 other priests who he could not identify. He could not name them. One of the 2 priests there at the time was the same priest that the other brother had been accusing. However, this gets really convoluted. David Grover claimed in this police report that he went there to this rectory with me because we had a positive relationship and he had no reason to suspect anything had been wrong, could be wrong. 2 months earlier, he told the same detective that over the previous 4 years I had raped him repeatedly in the other rectory. This was making no sense, and there was just no questioning at all. It was simply a narrative repeated by the detective with no sense of any prompting, of any questioning, nothing whatsoever. And then at some point, this detective or the accusers or their contingency lawyers became aware of these time parameter conflicts. And so there's a new police report with all of them, and the detective gave them a copy of my resume so they could get there, so they could actually accuse me at a time that I was there. And then there was a whole new set of interviews and a whole new set of accusations and dates as if none of the other interviews had ever taken place.
Do you have copies of those previous interviews?
We do, yeah. And they were all presented in discovery. And I think, in hindsight, looking back on this, there's a sense that once the state becomes aware of these sorts of problems with accusers in a trial, the plea deal offers start surfacing. But we weren't even through yet with the accusations. Then a 3rd brother came forward, completely excluding all the information of the other 2. He claimed that when he was 15 years old, which would have been the summer of 1983, in the weeks just after I arrived at this parish, he claimed that he came to see me for counseling for his drug dependency. He claimed that he was forcibly raped at each counseling session in my rectory office, and that each week he returned for counseling, unable to remember that he was raped the week before. There was no consultation with an expert to see if this was even possible. This, again, was just thrown out there. We have this claim, now we have an indictment, and then that was the case that went to trial. From day one, I maintain and still do that neither the counseling sessions nor the sexual assaults ever took place. This was a young man who, at 15, 16, was 5'11", 180, 190 pounds, and the claim was that I had shut the door, tackled him, raped him, let him go, and then he came back for his next appointment a week later. This made no sense whatsoever. Then the plea deal offers began. I was offered originally a sentence of 7.5 to 15 years if I would plead guilty to one of these claims and dismiss the rest. I refused it. A few months went by, and then the offer changed to 3.5 to 7 years, and I refused that. And then a few months after that, there was another offer, and it was the state's last best effort, the prosecutor's last best effort. He put in writing to my attorney that I could serve a sentence of 1 to 3 years if I would agree to plead guilty to one charge. And this really created a dilemma for those who were defending me, because the lawyers at least knew the risk that we were taking by not taking a plea deal. And so my attorney sat me down and told me that innocent defendants plead guilty all the time to control a sentence, but I just couldn't do it. In fact, during the trial, during testimony at the trial, as Thomas Grover was describing out-of-body experiences and these counseling sessions, which never took place, we had a break in the trial, and at the end of his testimony, the prosecutor repeated his offer and changed it. It would be 1 to 2 years in prison if I would stop the trial at that point and plead guilty, because it seemed clear to me that he himself did not believe what was being said up on the stand. So we had a break in the trial, and my lawyer discussed this deal, this offer with me. I told him I didn't feel I could do it, and he asked me to take 10 minutes and think about it. So I went to a telephone in the lobby during the trial, and I called an attorney for my diocese, and I told him I didn't think I'd get him, but I did get him, Attorney Brad Cook, and I told him about the offer that had just been presented to me. I asked him what would be the repercussions for the diocese in the event that I took such a deal. I told him that I was leaning so heavily against it, and he said it would make it more difficult for us to defend against the lawsuits. Then I called a friend who was a canon lawyer, and I asked him what would be the canonical repercussions, and he said you would be dismissed from the priesthood. So I walked back into the courtroom and refused the deal. When I refused the deal, the court became very irritated with me because I said that this deal would be a negotiated lie, and I'm not participating. In the end, it turned out over time that my diocese did nothing to defend against the lawsuits. I did not even know that even before trial, settlement negotiations were already underway. And this is part of the problem, which I'll get into a bit later. There was a lot prior to the trial that really disrupted our defense, and not the least being our inability to obtain basic information. The trial was very underfunded. Most priests cannot afford a criminal defense. There's been a lot of criticism of defendants like Michael Jackson, who put millions into defending himself. But I read that even with the millions he put into defending himself, it was less than what the state invested into prosecuting him. Most priests cannot really defend themselves in a criminal court against criminal charges. And so they're really at the mercy of either a free attorney whose own Catholic faith prompts him to want to take such a case, or a public defender. And I've seen too many priests who are accused whose future is relegated to the care of a public defender, and the public defender too often sees as his only obligation is to negotiate the best deal that he can. There's really no effort to try to ascertain the priest's innocence or defend against his guilt. I've seen that more often than not, and it's a little scary. It's not the way this works on Law and Order at all.
It's very scary.
It's very scary.
Priests have lost their civil rights as far as I'm concerned.
They have. What made the trial more complicated was that before jury selection in my trial, while knowing that I maintained my innocence of the charges and knowing that we were fighting to put together a defense, I received a phone call one day from an Albuquerque Journal reporter who asked me what my feelings were about the press release that had just been issued from my diocese. I had no idea there was a press release. I had not seen it. And he read it to me over the telephone. Nothing in this whole process left me devastated as much as this press release. And we never understood what prompted it. But months before jury selection was scheduled in my trial, my diocese issued a statement saying, "The Catholic Church has been a victim of the actions of Gordon MacRae, just as these individuals accusing him have been. The Church mourns with these victims. It is clear that he will never again function as a priest." And here I am about to enter into jury selection in a trial, and this press release hits headlines throughout New Hampshire and then in New Mexico. And we were devastated. My defense attorney was completely demoralized. My canonist got on the phone, Father David Dybel, and contacted the chancellor from my diocese, who was the author of the press release, now the auxiliary bishop. And his defense was twofold. He said this was carefully crafted to answer the media inquiries about Father MacRae's case, number one, and number two, we didn't think he would even see this way out in New Mexico, where I was living prior to the trial, preparing for the trial. It was devastating, and my attorney said that my civil rights to a presumption of innocence in a fair trial had just been terminated. And to this day, I have never received an explanation for this. The only explanation I can assume is that at that moment, the diocese was in settlement negotiations with the attorneys for the accusers, and this was something that the attorneys asked for. And so it was given in exchange for a lesser settlement, I don't know. Jury selection became very difficult because just about every Catholic juror had seen that press release, and when questioned said that the declaration that I had victimized the entire Catholic Church would definitely weigh on their decision making. And so we ended up with an almost entirely non-Catholic jury because of this. At the trial itself, there were many issues that had surfaced. It was a three-ring circus. Excuse me, pardon me. The county attorney, which is the New Hampshire version of the district attorney, the DA, the county attorney's office was being contested in a election, pending election, and the prosecutor used the notoriety of this trial to wear his campaign button. And so during the trial, he was reprimanded by the judge in order to remove the campaign button. But then some other things happened at the trial. And one of them, and again, the jury was just oblivious to all of this. At a point in the trial, as the accuser was testifying about his claim that his testimony was actually very simple. This enormous man sat on the stand and said that when he was 15, it was actually the 3 months preceding his 16th birthday, he was in my office for counseling for his drug dependency. He said that that I shut the door, locked it. Nobody ever went to look to see if those doors had locks. They did not. And then walked across the room and unzipped his fly and forced him to undergo oral sex. He said that when I finished, I simply went back to my seat and we continued the counseling. And that this happened 5 weeks in a row, 5 consecutive sessions. And obviously there was going to be some cross-examination here. So as my attorney, who was also a big guy, stood up, the defense table was a little bit like this table. I was sitting here, my attorney was sitting here, The center aisle was right here. My attorney stood up to question Thomas Grover. Immediately, Thomas protested. He put up his hands and turned to the judge, Judge Arthur Brennan, and he said to the judge, "I can't answer his questions." And the judge said, "Why not?" And Thomas said, "Well, because he's standing too close to him," meaning me, "and I don't want to have to look at him. I can't bear it. I can't bear to look at him during this trial." This was not a 12-year-old. This was a 27-year-old man. And so the judge ordered my attorney to walk to as far in the courtroom as he could physically go and to conduct his cross-examination from way over here. And so he did. And Thomas just, when he was asked to explain why he came back from week to week after being raped, as he described in my office, he said, "I don't know how I got there, I repressed it." So my attorney pushed him and said, "Can you explain this repression?" He said, "I had out-of-body experiences." So my attorney asked him to explain it. The man paused and then suddenly started sobbing uncontrollably. The judge ordered a break in the trial. During this break, a woman approached my attorney and she said, "There's a problem here." And my attorney said, "Well, who are you and what is it?" And she introduced herself. She said, "I've been sitting here watching this, and there's a woman here in the courtroom who is influencing his testimony." She said, "At the time that you asked the question to explain his out-of-body experiences, I saw him staring at her, and so I looked like this to see her, and she went like this." And then he began sobbing on the stand. The woman, the observer who saw this, said that the issue was not that you were standing next to MacRae, the issue was that you were blocking his view of her. So my attorney asked for a break in the trial, and the judge declared another recess, and my attorney walked up to this woman and asked her name. She said her name is Pauline Goupel, and she introduced herself as a therapist hired by Thomas Grover's contingency lawyer to counsel him throughout the trial. The observer who saw this behavior said that the woman had actually done that, the signal to cry twice. The other question that prompted it was, who did you go to first, a lawyer or the police? And Thomas began sobbing on the stand again, but this woman had given the same signal to cry, allegedly. I did not personally see this myself, but it ended up in the end that 2 people witnessed it. And so Pauline Goupel, the jury was dismissed for the rest of the day. They were bewildered about what was going on. They were in the courtroom one minute, gone the next, and for the entire day they were sequestered in a meeting room below the court, and they had no idea what was happening up there. Pauline Goupel took the stand, and she defended her treatment file. We were supposed to have received all treatment records of Thomas Grover's treatment before the trial, but there was never any mention of her. Well, because she was retained by his contingency lawyer, her treatment of him ended up being protected by attorney-client privilege. And so the judge ordered an in-camera review of her file. And it ended up that there was no mention of me at all in her file, except for one letter, which my attorney was allowed to see. And it was a letter from her to the accuser, in which she said, "Jim," meaning Detective McLaughlin, "tells me that MacRae is being offered a plea deal he won't turn down. His lawyers won't let him, so we can proceed with the settlement phase." The jury was never aware of this letter, and the judge ordered that it's privileged material and can't be released to the public. It was put back into the file, but she was barred from the courtroom for the remainder of the trial. But it went like this all throughout the trial. It was a start, stop, start, stop. The jury was present, the jury wasn't present. And we never were able to get at any facts. There was never any explanation of why the original accusations were from 4 years prior to these accusations. There was never any physical evidence. There was never any presentation of whether or not the rectory office doors even locked. We since learned that they had been painted over decades earlier, but nobody ever bothered to go look. And then the state was...
I just want to check, I want to see to make sure how it's looking, because... Can you tilt it over this way more? Yeah, there you go.
I get the microphone.
I'll move it like that, but it's a better composition, but I like that. And if you get a little bit tighter as we get along.
Sure.
Good, good. Are we out? Is it out now?
Yep.
The mic, okay, great. Yep.
Then the state was permitted to put an expert witness on the stand. Dr. Leonard Flesher, EDD, took the stand, and his job was to educate the jury about child abuse accommodation syndrome, which he was not permitted to say by name, but that was pretty much his presentation. And delayed reporting, that sort of thing. As a witness, he was not allowed to be present in the courtroom. However, something happened that the jury never learned about. The woman who had been sitting in the back of the courtroom giving hand signals was seen in a restaurant with Dr. Flesher and during the trial. And it turned out that he was a mentor of hers in a graduate program that she was in. So they knew each other quite well. So Dr. Flesher's testimony presented some verbatim quotes from the accuser on the stand, which his prescience in this was just amazing. But he even used terms like out-of-body experiences and that sort of thing, really corroborating for the jury that, as bizarre as all this sounds, this man's telling the truth. Dr. Flesher then also told the jury that prior to that, Thomas Grover had testified that he has been, as an adolescent and an adult, a patient in 6 residential drug treatment centers without success. One of them was Beach Hill Hospital. Dr. Flesher told the jury that he was once a therapist at Beach Hill Hospital, and in his experience, 80 to 90% of the patients there were sexually abused as children and teenagers. This uncorroborated statistical opinion swayed the jury entirely. At the end of the trial, we really put on no defense. There was no defense to put on. One priest, the sole priest who agreed to come to the trial without a subpoena, testified that the accuser's claim that we had played chess on an expensive marble chess set in my office just before being raped in 1983 was not possible, because I had purchased that chess set in 1986 while on vacation with this priest in Bar Harbor, Maine, and that he knew me never to own a previous set of marble chess set like that. And he said the chess set described was clearly the same one that we purchased, but it couldn't have been in my office in 1983. He presented, he actually still had his calendar from 1986, and it showed that we were on vacation in Bar Harbor at that time. And the jury at the end asked to see a transcript of this priest's testimony, but the judge denied it, stating that they're going to have to go on their memory. The judge also refused to allow the defense to bring before the jury Thomas Grover's criminal record, which included charges of fraud, forgery, burglary, assault, all sorts of false pretense charges. And the judge ordered that those offenses were from his juvenile record and from too long ago to be pertinent to the trial, but they were from the same time period as the claims in the trial, which made no sense whatsoever. So we were really crippled from offering a defense. As the prosecution rested, the judge addressed me in open court, which is very unusual, but outside the presence of the jury. The judge told me that if I take the stand in my own defense, he is going to open the door to allow the unrelated, what he called unrelated charges of the other accusers to be entered into evidence. And they will simply serve to corroborate Thomas Grover's story. And so my lawyer told me, you can't take the stand in your own defense. So we ended up with no defense at all. In the end, the judge instructed the jury that under New Hampshire law, in a case where there is no physical evidence like this one, the jury must determine whether it believes the story of the accuser over the story of the defendant. Actually, the judge called the accuser the victim throughout the trial. He said to the jury, you must conclude whether or not you believe the story of the victim over the story of the defendant. The defendant told no story. He did not take the stand. You're not to infer guilt by that, but you have to determine who you believe. And they came back in less than 2 hours with a guilty verdict on all counts. Judge Brennan sentenced me to 30 times the state's proffered plea deal, 33.5 to 67 years. In New Hampshire, in the New Hampshire system at least, a defendant is eligible for the lower sentence only if he publicly admits to guilt of the crime. And so that has been the dilemma. I would have left prison 15 years ago had I taken the deal the state offered to me. I do not regret not taking that deal. After the trial was over, the state, my lawyer resigned from the case. He just felt he could not defend against this case any further. There was no investigation. We needed a private investigator. There was none of that. So he left the case and went back to New Mexico. I was left in the hands of a public defender, and the state was offering a deal for the remaining charges involving the other two brothers and another person who had come forward during the course of the trial, also alleging 20-year-old behavior. The state offered a deal of 1 to 2 years, concurrent with whatever I'm going to be sentenced to, so it was no time whatsoever. I never thought I could be in this kind of position, but I'm in a county jail awaiting sentencing. Everyone has abandoned the case. I'm in contact with no one. And then the state comes forward and tells me that I must take this deal. So I got called to the jail. I was in the Cheshire County Jail awaiting sentencing. I got called to the jail director's office. And he had a call from my attorney in New Mexico, who let me put me on the phone, let me talk to him, and he told me, you have no choice. We have some good appellate issues. We might win an appeal in this trial. You will never survive 2 more trials. You will never survive 2 more appeals. You have no resources. You have no assets. You have no choice. And so I stood up in the court 2 weeks later with with another attorney's hand on my back, pushing me. And the judge said, how do you plead in these remaining charges? And I couldn't answer. Judge Brennan asked it a second time, and the attorney poked me in the back, and I said guilty. And then sat down, immediately sat down. I put my head in my hands. I just couldn't believe this was happening. And I walked out of that. I was taken right from there to the state prison. And a friend of mine who was in the court was outside as I was on the set-up perp walk for the media between the courtroom and the prison-bound van in chains and handcuffs. And I turned to him and I said, that was another negotiated lie. And he said, I know it was. And that's where it stood. Now,
how do you feel? We were ready to break
I feel like I need a shower after talking about this. For years in here, stuck in this prison, there's a mentality out there, and I hear this all the time, that prison inmates maintain their innocence even when they're not. That is so far from the truth. The repercussions for claiming to be innocent in prison are astonishing. Most people have no idea. There are housing units even within this prison that are considered the inner city and others that are considered the suburbs. Because I maintain my innocence, I have never been eligible for the suburbs. I spent my first 6 years in prison in a cell with 7 other inmates, sharing a cell the size of this room. It's nightmarish for most people to think of this. But most people go to the 8-man cells while they're awaiting housing in other units. But because I maintained my innocence and became program ineligible in the prison system, I spent longer than any other New Hampshire inmate in an 8-man cell, 6 years, as opposed to 6 months. Finally, after 6 years, around the year 2000, I was moved. I requested a move. I requested it 2 or 3 times a year, and it was always denied. And then finally it was granted, and I was moved to a cell, to a unit where there are 2 per cell. They're terribly small, but they were built for 1, but they're 2. And I was there until the Wall Street Journal wrote about my case, and then suddenly, a few weeks later, I was moved back to the 8-man cells again. It was horrific, and I spent another several months there, demoralized, demeaned, and then was permitted to move back.
Now, I read in one of your blogs that when you first arrived, you were beat up or something.
When I first arrived in the prison, I was placed in a solitary confinement unit, what's called SHU, the Special Housing Unit. It's amazing what you can adjust to. I was locked down 23 hours a day. I was supposed to be out an hour a day, but the out is simply a little cage, like a dog cage. I could make 11 steps across the cage and back again, the chain link above me on all sides. That was the hour out of the cell, and I adjusted to that. I was there a few months. And after a few months, because I adjusted, I asked to remain there. I wrote a formal request asking to remain there, at least for the time being, until I'm assigned housing, better housing. I received a reply to my request, "We have no intention of moving you." The next day I was moved to a receiving unit with full of young kids who were just coming into the prison. On the day I was moved there, someone had attached or pasted a newspaper article on the wall of the tier of cells. Nobody knew who I was at that time. The newspaper article was about my diocese pretrial press release. Church declares that it was victimized by accused priest. Somebody had put that on the wall, and the next morning I was able to see it, but because I was locked in a cell, I wasn't able to tear it down. The next morning my cell door opened at 5 a.m. and 3 men wearing stocking caps pulled over their faces, carrying sections of broomsticks, attacked me while I was still sleeping. And I was taken from there to the infirmary. Had some x-rays, and then moved to another part of the prison, back to the special housing unit. And then from there I went to the 8-man cells. I never found out who was involved in that incident. It has never been repeated. Not for lack of trying. I just wrote, in fact, last week on these stone walls about an incident that happened on the day Father John Gagan was murdered in Massachusetts. A news van from Channel 9 News in Manchester, WMUR, parked in front of the prison here, and the news reporter pondered for the camera on whether I would live out the week after the story of John Gagan being murdered in Massachusetts. And by that point I had been here 9 years, and the prisoners thought it was hysterical. Everyone told me I was in a lot more danger from that reporter than from anyone here, and I agree with that. Nothing happens.
Wow. What do you think was behind McLaughlin? Because it all
I
goes
don't
back
know.
to him, don't
It does all come back to every case involving an accusation, with the exception of after 2002. What prompted me to go to the Wall Street Journal was that, to Dorothy Rabinowitz, was that during the big settlement, during the big crisis that occurred in 2002, I was accused by two people I have never met, who simply saw my name online in the released files and decided that they were going to accuse me. There's another priest in here who pled guilty, who took a plea deal, and I believe he has said, confided in me, that he is guilty. It's not confided, it's public knowledge. He was in the infirmary one day, and shortly after I was accused by two people I've never met in 2002, he told me that he was accused by two people he has never met. And the same attorney brought each of these claims. So then I did a little research, and I found out that this attorney, Peter Hutchins is his name, in 2002, brought 64 lawsuits. There weren't even lawsuits. They weren't even filed in a court of law. He simply had 64 accusers against 28 priests, all of whom were listed on the diocesan website, and wanted a settlement. And the diocese wrote him a check for $5.5 million. This is an issue. This is an issue that must come out into the open. The attorney actually told, as the newspapers were covering that settlement, Attorney Hutchins is quoted in both the Nashua Telegraph and the Manchester Union Leader as saying, the diocese didn't even ask for details like names and dates or places, no corroboration whatsoever. I've never seen anything like it. A year later, he had another 60 clients, and a year after that, another 60. And he has come forward almost annually since then, with each year with people held in moderation until he obtains one mediated settlement to be followed by another, all of which ends up with a 40% contingency fee. It was then that I decided that I'm a sitting duck. And the only thing that's going to stop this is the publication of names of the accusers, and nobody is going to do that. So I had been in touch with Dorothy Rabinowitz, and I asked her if she writes about this, how she feels about printing the names of the accusers, and she had no problem with that. What was very interesting is that she wrote 2 articles over 2 days. And at the end of the first day, she received a call in frantic protest of publishing the accusers' names. The call wasn't from the accusers, it was from the attorney for my diocese, who argued with her that the promise not to ever reveal their names was part of the settlement, and that non-disclosure, that the diocese had entered into non-disclosure agreements with these accusers. My statement was that I was never a party to any non-disclosure agreement. I was never even told that a settlement had taken place. I wrote letters specifically forbidding.
How's our tape?
You have to change up now.
Okay,
So,
great.
yeah.